Hello, and thank you all for coming. My name is Stephen Mathis. I'm a postdoctoral researcher on the Dimensions project at the University of Bergen, and I'm the moderator of this panel. And it is the product of a UiB CMI collaboration grant, networking grant. So we're very thankful for that. And I want to say right off the top, thank you very much to Laura for her invaluable help getting all of this together for us. So the way this is going to go is we'll have a keynote from Professor Linda Gröning, and then we'll have a panel with some of our guests. So just to introduce Linda briefly, Linda is professor of criminal law at the University of Bergen. She works on the intersection of criminal law and psychiatry. She's also the PI on a couple of grants, the Dimensions project that I work on, and a new one starting next month called the Child Crim project. She's also was a member of the Law Commission following the Breivik case here in Norway, and she's a member of the Permanent Criminal Law Commission. What's that? Oh, the chair, excuse me, not member, chair. I wrote that down incorrectly. Forgive me. Linda, please.
Thank you so much. And thank you, I must say, to Laura and Siri and everyone that is organizing this absolutely fantastic Bergen Exchanges program. Unfortunately, due to conflicting other events, I have not had the opportunity to attend so much of it before, but I know from previous experiences, previous year, that you are really created and very important institution here, actually, I think, for gathering people together and exchange views and research and understanding experiences across countries and across disciplines. So thank you so much. I will talk for 30 minutes. And my talk has the title of Criminal Unaccountability and Mental Disorders, Challenges for Cross-Country Research. What I will attempt to do is that I will, so to say, provide a sort of a backdrop for the panel debate that we will then have. These matters are really challenging. And I will, of course, not have the time or possibility in 30 minutes to cover all issues in this area. They are spanning from like conceptual problems to legal doctrinal problems to different interdisciplinary other perspectives from different sciences that has noticed other problems, and not least to, so to say, sociological problems relating to the situation and experiences of the persons that are, so to say, subjected to the control of the criminal justice system or related psychiatric or mental health facilities. The key question that I will concentrate my lecture on is this: what is the legal relevance of mental disorders for criminal accountability and punishment? And this is actually a question that may be quite easy to formulate, far more difficult to answer. We could start with setting, so to say, the scene. What we are talking about in law, in criminal law, in this area, is a truly challenging issue. Media has, so to say, the last decade at least, provide also an increasing attention to, in particular, the most horrifying and extreme cases in this field. On this picture, you see, to the left maybe, and then media wasn't that active, but maybe he is the man to blame for everything, or at least what follows his case. This man in black and white is Daniel McNaughton from England. Actually, I think maybe Ronnie McKay, who is in the audience, will elaborate, I guess, a bit more about this case. Nevertheless, this man was suffering from delusional beliefs and wanted to kill the, at that time, English Prime Minister Edward Peel, but he mistaken his secretary, Edward Drummond, for being Mr. Peel and murdered him. In the procedure that followed, I guess he was considered not guilty by reason of insanity, which, similar to what we see today, created a large response in the public debate. This was not, we could not live with such a thing. After that, I think instructed by in English and ancient, and I think now, Ronnie, you have to excuse me if I mix up details here, and you should correct them afterwards. Nevertheless, after his case in 1843, the so-called MacNaughton rule was established. And this rule then is saying basically that in order to be understood as insane, you cannot, so to say, understand what you were doing were wrong in a very brief. Ronnie will come back to the full formulation of the rule. Nevertheless, this rule was spread all over the world. Noteworthy is that England still uses it. Okay, the other woman up in the left is Andrea Yates from the US, who drowned her, I think, 5 children in the bathtub. Also in a state of, in her case, a postpartum depression. She was diagnosed with a psychotic disorder and excused by reason of insanity. I don't know if she has left the hospital yet, or if she is still in a forensic ward. She is out. The man here is, I think, his name is Morrow Denkin. He is from Australia and killed his grandparents and a retired police. Also a case that were out in media. He was considered insane and was considered to suffer from schizophrenia. As the same was the case with the other one who was in Ireland, James Kilroy, and killed his wife and was excused by reason of insanity and was understood to suffer from schizophrenia. The man down here was Anders Behring Breivik, who committed these horrendous criminal acts in Oslo and in Utøya, followed by a procedure where the key matter was whether he was psychotic or not, whether he had a psychosis disorder or not, or whether he had just personality disorders. The court chose the latter, as I will return to, and he is the only one in this picture who was not found insane by reason, or not guilty by reason of insanity, but he was punished to preventive detention where he still serves his sentence. The point here is to remember is the media focus here is typical on the most severe cases. The reality is in the criminal law that many of these persons that are, so to say, tried for whether they are unaccountable or not by reason of mental disorder are not like this. There are many much less serious cases with very mentally ill persons. And this is a challenging issue because it is actually what is at stake is the most fundamental issue in criminal law. It boils down to the most, so to say, the idea of the responsible person. And it's also very important because what is at stake is actually whether you're criminally accountable or not, whether you should be punished or you should be acquitted. And this is really important to remember because this doctrine, the criminal insanity doctrine as it's called, is often discussed as if it's a matter of whether you should be punished or sentenced with compulsory reactions. But it's actually a matter of whether you're guilty or not. But it also functions to justify, typically, in most countries, in the track of non-accountable. Most countries have some kind of dispositional measures to capture the risk for new crimes, typically in some form or another of compulsory psychiatric care. In the other track, so to say, it can of course also happen that there is a risk for new crimes, but there is the punishment, which is often fault-based, that operates. Some countries or many countries in one way or another is also opening for dispositional reactions, either after punishment or, as in Norway, a hybrid punishment that is risk-based, which is preventive detention. Okay. I will briefly take you through the conceptual starting point of what we're doing, what we're dealing with here. As I just already touched upon, what is at stake is our conception of the criminal laws person. And now I want to give you a very quick, so to say, explanation of modern criminal law as I conceive of it. So the conceptual starting point for the criminal law is, to put it very briefly, that humans are assumed to have the capacity for freedom of reason in thought and action, and thus capacity to act morally and to follow the law. It is a fact that the criminal justice system or the criminal law operates with rules or regulation, prohibitions or commands that you ought to do certain things, or typically you ought not to do certain things, such as murder another human being. If you do not respect these commands, these norms, you're blameworthy and can be punished. Okay? So in this, the criminal expects you to have the capacity to understand and respond to these reasons provided by the norms. So if you do not have this capacity to reflect about what is right and wrong to do, and in this respect to internalize the prohibition or the norms of criminal law, then you cannot be understood as guilty. Okay. So the criminal law from this starting point typically is centered on the fundamental principle of fault. It says that only those who could and should have acted differently and therefore deserve blame should be held accountable for their actions. I usually say to my students that if you understand this principle, then you understand the full and entire criminal law. Because actually this goes through, if you think about it. Okay, we do not hold children accountable, small children at least, we're quite agreeing on that matter. We don't think that people are to blame if the, so to say, lightning struck their car and therefore they lose control of the car and hit someone who walk at the side of the street. We usually think that mere coincidence, force majeure, etc., are not something that we should hold blame for. We usually blame our friends if they are too late because we expect them to have known better and done better. We usually praise each other if we think we deserve it. And we typically praise each other or blame each other in proportion to what we deserve to be blamed for or praised for. Therefore, we typically punish theft less severe than murder. Okay. From there to the legal doctrine of criminal insanity. As you may have already now understood, this doctrine concerns the defendant's lack of capacity for responsible action, criminal unaccountability. It provides, when applicable, a general excuse, at least in theory, from responsibility of punishment, meaning that it doesn't matter on whether it is theft or murder. We see, though, in practice that it does. The international criminal law has an insanity defense. It's never used. We have seen in terror cases, such as the Bergen case in Norway, that many of these end with sentencing. Okay, let me turn to the legal relevance of mental disorder. Mental disorder is relevant today. We see it everywhere, where I started. Diagnosis, symptoms, ideas, psychiatric constructs are associated with the legal understanding of unaccountability. And this is so principally not because mental disorder is relevant as such, but because it's understood to produce certain impairments, functional impairments that are considered legally relevant. That is, if we go down essentially, impairments in the ability of, so to say, freedom and reason in action. So a diagnosis is, of course, principally neither sufficient nor necessary for criminal unaccountability. Diagnosis classifications such as these are developed for other purposes than to decide who is to blame and punish or not. They're developed for treatment purposes or similar. But still, since modern psychiatry entered the legal scene, forensic experts have become the key premise providers and have large practical influence in most countries. So, the Norwegian example for this case was in many ways a trauma for Norway. And I would not go into, so to say, the substance of this case as such. But this case is also the debate that followed it so clearly reflected how intertwined law and psychiatry have become. During this case, the defendant were diagnosed by experts in the case and expert witnesses with 7 or 8 different diagnoses, ICD-10 diagnosis. He was also diagnosed in media with at least as many as in the case. In the end, it also turned out to be like criminal unaccountability was a matter of which diagnosis that was the proper one for this man. This is just one quote from the court's judgment, and of course not the full story. But it shows that how in the legal reasoning, the court says that the court's conclusion is that the defendant did not have the symptoms to fill the general ICD-10 criteria for schizophrenia, the way these criteria are normally applied in clinical and scientific practice. Okay? And this formed the basis for the judgment. We see the same across countries. I have learned already by participating in this Bergen exchanges and from meeting Luisa Kadiju, that this is also the case both in Brazil and Zanzibar. Norwegian model, though, is a little bit specific internationally because most countries, as I said, are influenced by the English McNaughton or similar standards, applying both, you could say, a mental disorder condition in some version, and in addition, a requirement that the mental disorder must influence the crime. Norway does not apply this model, and in this sense, Norway is unique in the world. What Norway does is it is only applying a, so to say, mental disorder condition or a condition of a state. So if one should simplify, one could say that all what matters in Norway is that you were, so to say, sufficiently disordered while committing the crime. But there is no assessment how this state of the disorder influenced the specific crime. And the focus is still on the state of being disordered and on the functional impairments related to that state, which then aligns well with its underlying conception and relevance of mental disorder. The current criminal law, and this is also an interesting matter for cross-country studies, because we always in criminal law needs to go from concepts to concrete rules and regulation that should steer practical judgment with significant impact in people's lives. So therefore, we need to try to formulate our concepts in words. And this is not easy. And these words, these rules, doctrines, regulation, should also be able to prove in court. They should be not, so to say, offensive in their style. There should not, they should be clear, foreseeable within the civil law countries. We emphasize legal certainty. The Norwegian current rule, which we got after the law reform following the Breivik case, is this. And I have now highlighted the, so to say, criterion, which is about mental disorder. It's, as you see, a common language formulation. The requirement is that you have to be unaccountable due to a severely deviant state of mind. And this is literally translated. So this criterion covers the state of being psychotic as a state of having a severely impaired reality understanding, which is a functional impairment, a construct used in mental health, typically associated with positive psychosis symptoms such as delusions or hallucinations. Okay? And in addition, it is equally, so to say, severe states of mental disorders as being psychotic in this sense. It's a narrow rule, I would argue, in the Nordic countries at least, is the most narrow standard. But still, it's consensual in its wording or common language. And one of the underlying really intentions behind the law reform was to, so to say, create a clearer distinction and demarcation between criminal law and psychiatry. So one wanted to take away psychiatric terminology from the rule, and one did also, so to say, diminish the role of the experts in court. Before they could also conclude about legal criteria, they cannot do this anymore. They're only allowed to inform the court about their specific expertise, while it's up to the judge to decide on the legal standards. So far, so good. Before I enter into how it looks like in practice, I will also briefly get you a little bit to what happens, what is at stake. And here it's really important to remember that the criminal insanity doctrine and the mental disorders relevance is a very narrow formulated doctrine. And this is, of course, because it's about who we, so to say, recognize as persons, as agents in the criminal law. It is a autonomy-based, I would say, doctrine. So if you're not understood as accountable, then what enters the scene typically is that we're not recognizing you as an autonomous, free, reasonable person. Thereby, we may also use it to justify compulsory paternalistic interventions. So therefore, it's a serious thing. You should be very careful about expanding this doctrine too much. That is one thing. The result of this is, of course, that this is not a, so to say, the threshold is not determining a demarcation between well or mentally ill and healthy. It is a demarcation between very mentally ill and very, very mentally ill. So all countries applying the insanity defense accepts that we are sentencing many very mentally ill defendants to prison. There are two tracks in Norway. We have the prison tracks, which I already have mentioned for you, where we have punishment, regular punishments of different forms, including imprisonment. And we have in Norway a very special hybrid reaction called preventive detention, which is a risk-based punishment. So it requires guilt, accountability, but it's also forward-looking. So it can be prolonged for indefinite time, and it's prolonged on the basis of risk assessments. These are for those considered accountable. So we have many mentally ill offenders in prisons. Okay. On the other hand, we have two types now in Norway of disposal responses. And the original one, and I say original because the starting point is that people that are not guilty should not be subjected to criminal control. Okay? These reactions are dealt with as criminal reactions. So the first form is only to protect the life, health, and freedom of other persons. So you could at least to some extent justify that from the underlying values of the criminal law. The second form is new from 2016, and it's limited to 3 years. And it's introduced as a response that the criminal law want to control persons that are, so to say, considered not accountable. Therefore, they are acquitted. They are released on the street. They are committing new crimes, typically under a psychotic episode, maybe driven by intoxication. Then they're getting to the hospital where they are well medicated and better. They're out again. Soon they relapse into new psychotic episode, commit new crimes, and back in hospital. So they go back and forward. What do? Yes, we make sure that they are not coming out. Okay, this is the control logic. So what we see in Norway is, despite this intention now, still, and even to a higher degree than before, diagnostic evaluations are influencing legal judgment. This is just one example from the Oslo District Court in 2021. Again, you see the diagnosis of paranoid schizophrenia at the time of the act, seemingly decisive for the verdict. At the same time, it is clearly unclear how these diagnostic constructs and how symptoms, etc., are really relevant to criminal unaccountability. It is really difficult from reading court judgment to understand, so to say, how these normative ideas of unaccountability and standards are really associated to the fact the person had a certain diagnosis or maybe was suffering from certain symptoms. It seems to be variation across cases, so that two equally severely ill persons are treated in different way. I mean, in the end, that means that one of them is acquitted, the other one is punished, or that one is subjected to compulsory psychiatric care and the other one is punished, etc. And this is, I would argue, a rule of law problem. It's a problem concerning equal treatment of severely mentally ill persons. We also have in Norway an explicit exclusion of psychopathy. So while the intention is that we should not associate the law so strongly with psychiatry, this exclusion is based on a diagnostic category. And it is, so to say, this is a quote from the Standing Committee of Justice in the bill underlying the rules, saying that it will be defined by the wording of the rule and in the law motives which characteristics that are relevant in order to avoid that persons with, for instance, dissocial personality, earlier psychopathy are included. And then, of course, one could argue why. And we know today that at least there are some with severe impairments that are, so to say, under the label of personality disorders that may have such functional impairments, at least that we should ask the question of whether they could be equally impaired as someone with, for instance, a psychosis disorder. Okay, and at the same time, this personality disorder constructs are often justified preventive detention because they're associated with legal notions of dangerousness and risk. Again, so as you have understood, and now I will soon end this lecture, that the problem, or one problem, a key problem in my view, is that legal concepts of criminal unaccountability are clearly associated with psychiatric constructs that are not developed for criminal law purpose. By doing so, we are blurring what's going on in the law. At the same time, it's a fact that we are having many mental ill persons, both in prison and, of course, in the forensic and mental health facilities. We also have an increasing human rights discourse pointing to the facts that there are also massive suffering within these institutions. Norway have repeatedly and just also recently paid attention to isolation of mentally health inmates, women as a particular problem, children, etc. So this is a problem with huge consequences. I say that the main challenges in Norway and other countries, equal treatment is a core legal ideal, but in this field, it's not a practical reality. Don't misunderstand me. I'm not against forensic psychiatry or psychiatry, but I'm favor that in case psychiatric constructs are utilized for such severe decisions, we must be able to provide clear legal explanations of why and how are they relevant. Currently, we do not. The use of dispositional responses increases. This is an interesting matter that maybe we'll continue to discuss, but we live in a rich country. We have money to build facilities. And this is a double-edged sword. We see that now, since after the law reform, and after in particular the possibility to utilize more dispositional responses, all of a sudden there are more insanity verdicts. Is this because people has been more, so to say, severely mentally ill in criminal law, or is it because we have a new opportunity to subject them to compulsion? I will not prevent answer, but just raise some provocative questions. So I also think, as I also started with, that how criminal law associates unaccountability with mental disorders and how the law is handling mentally ill defendants is a problem across countries. But we know little about this. In my view, and this is why we're here, and this is why we're also having this pilot project with the CMI-UiB funding, that it is true significant of cross-country studies. We have a very limited understanding, in fact, of how the law conceives of the matter. Because, in particular, empirical legal studies and comparative studies also are largely absent. We lack data about the matter across country, maybe because this group we are talking about are the most marginalized persons in society. This is a book I can warmly recommend. We also have one of the editors in the audience. It's one of the few, Ronnie is one of the few in England that has really put an effort in carrying out empirical study. There are barriers and challenges. And this is maybe why it's so difficult. In addition to the, like, so to say, the political barriers, we have language barriers. Europe is like a Babel's tower. We do not understand, we cannot reach each other. It's difficult to access this. The national character of criminal law reinforces this problem. It is truly difficult and time-consuming to access data. This is just a picture. Many countries, many legal archives are still using handwritten paper. Okay, it is bureaucratic barriers. It is hidden by power and resources, not least, because this is why this is so important to break through, because we need to put the data, I think, on the table before we can really understand the matter and really put some force behind important policy criticism that is going on. So this is why we're here. We hope to encourage dialogue. Thanks.
So quick introductions for our panel. Do my best here, so bear with me. All the way to your left is Professor Luisa Ferreira, Professor of Criminal Law at FGV Sao Paulo Law School, and researcher at the Center for Studies on Crime and Punishment and the Center for Gender and Law. Next to her is Alicia Yamin, sorry, lecturer on law and the senior fellow on global health and rights at the Center for Health Law Policy and Management at the Harvard School of Public Health. More or less? Help me.
One is at the law school and one's at the School of Public Health. Doesn't
Okay,
matter.
fine, thank you. Next to her is Dr. Khadija Omar, a psychiatrist, forensic and otherwise, at Kidango Chikundu Psychiatric Hospital in Zanzibar. And next to her is Ronnie Mackay, who's been mentioned now a couple of times by Linda, Professor of Criminal Law, Professor of Criminal Policy and Mental Health at Leicester de Montfort Law School. And Linda I have introduced. So here we are. And I wanted to ask Ronnie to start because as Linda mentioned, the English approach to criminal insanity has been very influential around the world. And Ronnie is probably the leading scholar on that in the world. So he's a good person to introduce it to us and add a little more background like Linda did with the Norwegian system.
Okay, right.
Yeah.
Thank you.
So, and your microphone's there.
Thank you.
This is for us.
All right. It's a great pleasure to be here, and it's been very interesting hearing about different countries and their different approaches, and we just don't know enough cross jurisdictional. And that was part of the reason for the book that Linda mentioned, International and Comparative Aspects in the Insanity Defense, because we had to choose certain jurisdictions. So, you know, there are many, many others that we really need to investigate and look at, because the insanity defense is so fundamental to the whole issue surrounding criminal responsibility and mental disorder. I'll talk a little bit about the position in England and Wales. I say England and Wales because the United Kingdom has Scotland. I'm Scottish. I'm not a Scots lawyer. I'm an English lawyer trained in England. Scotland has its own insanity defense. The Northern Ireland has its own insanity defense. England and Wales has its own insanity defense, based, of course, on the famous or infamous, depending on your viewpoint, McNaughton rules, set down in 1843. And they, so far as I'm aware, they're absolutely unique as a form of lawmaking, because we have an insanity defense which is not subject to the democratic process, in the sense that it's never been enacted by any statute at all. Instead, what happened when Linda mentioned about Daniel McNaughton being found not guilty by reason of insanity, there was a public furore as a result of this, because he tried to kill the Prime Minister and had killed his private secretary instead, and people were very upset about it. And the result was that Parliament was asked to debate the insanity defense, and they resorted to an old procedure whereby the House of Lords, the second chamber, could ask the judges what the insanity defense should be. So they formulated a series of questions and gave them to the judges. We don't know who formulated the questions and how they were formulated. Nonetheless, we have these 4 questions which the judges were asked to answer. The Lord Chief Justice, who was then Lord Tyndall, wrote in longhand what the answers to those questions should be. That runs to about 3 pages. This went to 13 judges. There were 13 judges at the time, and 10 have signed the McNaughton rules. So 1 dissented and 2 did not sign. So this is interesting in itself, because the rules have been followed in English law since 1843, and remain unchanged. And of course, they've been extremely influential across the common law world. You name a common law jurisdiction, and it's more than likely that their insanity defense has been influenced by those rules. So you take Canada, you take India, you take Australia, you take New Zealand, you take most of African countries which are common law based, they're all influenced by the McNaughton rules. You take the United States of America, they were initially all influenced by the McNaughton rules until the Model Penal Code, and then a lot of states in the US decided to go down the Model Penal Code route, which is different from the McNaughton rules, until you get the Hinckley case, where John Hinckley attempted to assassinate the President of the United States. And it was just like McNaughton, a cause célèbre case, everyone very unhappy about Hinckley being acquitted on the basis of insanity. Suddenly, what happens is a lot of states in the US go back to the McNaughton rules. So the McNaughton rules have been fantastically influential. And what they say basically is this: the accused must prove. So the balance of proof is, the burden of proof is on the defendant, on a balance of probabilities. He or she must prove that at the time of the commission of the offense, he or she was suffering from a defect of reason, from disease of the mind, such that he did not know the nature and quality of his act, or if he did know it, he did not know that what he was doing was wrong. That's it, right? So this has been interpreted now in such a way in England and Wales that the defense is very difficult to satisfy. I've been looking at the McNaughton rules empirically for years. Initially, we had hardly any successful insanity defenses at all. We had about 5 or 6 a year out of the whole of the criminal process in England and Wales, all these criminal trials, 5 to 6 people. Why was that? Because if you were successful, you were sent to hospital indefinitely. It didn't matter what the offense was, you went to hospital for an indefinite period of time. So no one wanted to use it. Why would you use it? If you've been charged with theft, you'd rather plead guilty and get a minimal sentence, or even get probation, rather than be sent to hospital indefinitely. So as a result of research I did, the law was changed to introduce flexibility in terms of the way that the judge could deal with an insanity acquittee. So we no longer have to send that person to hospital indefinitely. The judge now has discretion. So my hypothesis was, well, if that happens, the numbers will rise. And they did. They rose up to what we've got today, which is about 25 to 30 successful cases a year. Now, that's quite a big increase, but it's still tremendously low. 25 to 30 insanity acquittals a year in the whole of England and Wales. It's very small. Why is that? Because it's very difficult to satisfy, not because of the rules themselves, but because of the way that the judges have interpreted them. It's as simple as that. How have they interpreted them? They have interpreted them to mean that the defect of reason from disease of the mind from which the defendant suffered means that he didn't know what he was doing, or he didn't know it was wrong in the sense of legally wrong. Now, for a person not to know what he's doing, basically, he's really almost got to be an automaton. Right? Or if he doesn't know that it's legally wrong, he's got to be so severely psychotic that it's very difficult to satisfy. Okay? So let me give you an example of a case. Here is one of my cases. You have a young woman of about 24 years of age. She has a 3-year-old daughter. She slowly, over a period of about 2 hours, extracts each and every one of her daughter's milk teeth. So she takes them out as gently as possible, right? There's screaming, there's blood. There are about 10 milk teeth that she takes out one by one, right? She's suffering from schizophrenia. When she's examined by the psychiatrist, they say, why did you do that? Did you not know that when you did that, you were causing harm to the child? Oh, yes, of course. So you knew the nature and quality of your act? Yes. So why did you do it? I did it because the devil was in the teeth and the teeth had to come out. So you knew that what you were doing was harming the child? Yes. So you knew it was legally wrong. Right? Now, strictly speaking, no insanity defense, because she doesn't satisfy that limit of the McNaughton rules. Right? Now, if you're not going to find that person criminally unaccountable in a case like that, then you've got an insanity defense that is ridiculous. The judge, very fortunately in that case, said to the jury, look, I don't care what the law says, I'm directing you that this woman should be found not guilty for reason of insanity because she thought that what she was doing was morally right. And they acquitted her, right? But unfortunately, not all judges will go down that route. And so we have a law which is so difficult to satisfy that what you get each year is about 25 to 30 successful cases a year. If we could have the judiciary interpreting the rules in a sensible manner, then we could expand the numbers and it would make much more sense. But that has just not been the case because we've had 2 appeal court cases recently who've confirmed the strict law in the McNaughton rules as has been interpreted means you must not know that what you're doing is legally wrong and nothing else. Right? So it's extremely difficult. So fortunately, in most jurisdictions that have adopted the McNaughton rules, they have adopted a much more liberal approach, except the States, United States, which haven't. But
Yes.
Canada, Australia, New Zealand have.
Well, so yeah, thank you for that. And I, in some of our discussions before this, there's a tie-in here with, so I'd like to go to Luisa about how Brazil does things on this front, and there's some parallels with what Ronnie was talking about as far as the past there, and how originally no one did the, would actually do it because they'd just be indefinitely. So yeah.
So yeah, I'll just catch up on that. So first of all, thank you so much for inviting me to be here. It's been a great week of like powerful discussions about this, and I really look forward to future collaboration because this is actually a very serious subject in Brazil and very, very neglected. There's almost no empirical research on people that are defendants that have mental health disorders, and we have no empirical research on how courts are dealing with them also. So we don't even know the rate and that statistic that Roni brought here of like 15 cases per year. 25 now. So we don't have that in Brazil. So it's actually very important to be here. And well, catching up on what Stephen brought up, I think that's one of the biggest challenges in Brazil. So I won't go into the requirements for someone to be considered criminally unaccountable. It's very similar to what we have in civil law countries. Different, it's not the McNaughton rules, but it's a requirement that you have to have a mental health disorder or intellectual disability, and you have to have practiced the criminal offense whilst having a mental health issue or that disability, and also you have to prove that you didn't know what you were doing or that you couldn't act upon that behavior. So that's very similar to many other countries. But the issue that I think that is most challenging in Brazil is what Ronnie brought up, what happens in England before they've changed it, is the fact that we have those 2 tracks also, like Linda explained. So if you're considered criminally accountable in Brazil, you'll have a criminal sentence and you have a maximum sentence, and we don't have that kind of pre-trial detention that Linda explained in her lecture. So if you finish your sentence, you'll be home, even if you're considered dangerous, or even if there's an assessment saying that you're a very dangerous person, you're likely to kill everyone. When you leave, you'd still go home if you get a criminal sentence. So if you're not considered insane. But if you are considered insane in Brazil, what happens is you then get a minimum time of confinement in a psychiatric hospital. And then that after you finish that minimum time of confinement, you'd be assessed and you could be there indefinitely as long as dangerousness persists. So just to tell you one quick story. When I left law school in Brazil, so that was 2010, 2010. I came up in a case I was working for a pro bono institution, and a case came to us. So it was Claudio Mido, I'll never forget him. And he was in a forensic psychiatric hospital for 23 years. And that caught my attention because I was 23 at the time. So when I saw the date that he was admitted, it was when I was born, and he was there for attempted theft, which is an offense that you could get, like you wouldn't even get a prison sentence for that in Brazil if you were considered accountable. But he was considered unaccountable due to mental illness, and he was there for 23 years, and he was just abandoned. And we took this case to court, saying, like, you know, it's attempted theft. And then court said, well, but you know, this is treatment. We're trying to cure him, and because he's still insane, or he still has a medical problem, or he's still dangerous. But of course, it's dangerous. She was there for 23 years in a forensic hospital with no treatment, and I'll get into that. But and then court said it doesn't matter what he did, but of course it matters, because if it hadn't committed the attempted theft, he'd never be locked up for 23 years. But that court decided that he should stay, and at some point he left. But yeah, so I guess this is our biggest challenge in Brazil, because it's so insecure for you to make that defense. No lawyer in their right minds would make an insanity defense in Brazil, and which means that we'll have many people with mental health disorders and problems in prisons, because that's safer, that's better for them if you're defending someone. But just to not make this so pessimistic.
Yeah. Yes, there is good news.
There's hope. From 2010 to now, there's been some improvements, and lots of them came from courts, actually, so which is very interesting. When we're like talking about law and social transformation. So what courts started to fix maximum limits to the confinement, even if the person is considered unaccountable. So first, a 30-year limit, which is the maximum sentence that you'd get in Brazil for any sort of crime. No, it's 40, but let's not get into that. But for 30 years, and then more recently, courts decided that it would be for the maximum time of the offense that the person had committed. So, which is really interesting from a philosophical point of view, because you know you're attaching the time that the person is confined to the criminal offense that they practice, even though they didn't know what they're doing or couldn't act upon that behavior. But still, I think it's a better way of treating them, because that's what happens when a person is serving, for example, a criminal sentence in Brazil. So they were considered accountable, and they developed a mental illness in prison, which you can imagine that it happens a lot. And then they would go to a forensic hospital, and there's a fixed amount of time. So they also could only stay there for the time that they had the sentence. So they did that too for people who are considered unaccountable, which has been very good. And another change that has come from courts in Brazil is the fact that I mentioned in the beginning that there was a minimum confinement period, and that happens independently of any medical assessment. So which is very retributive and also interesting from that perspective. But courts have decided that you cannot hold someone in a psychiatric hospital or in any kind of mental hospital without a medical assessment, or someone saying that this is really, like, you really have to, so you wouldn't be able to get help with outpatient treatment. So this has improved conditions, and there's a really recent development also in Brazil, which is the fact that they've decided to shut down all of the forensic psychiatric hospitals in Brazil. We have 28 hospitals in Brazil. They're under the prison system. They're supposed to be hospitals for treatment and care, but because they're under the prison system, of course, they care more about security than actual treatment. So the National Council of Justice in Brazil has decided to shut them down. And what happens is now, those people and people who are considered unaccountable and have to have treatment in a hospital, that is, they cannot have outpatient treatment for some reason, they can hurt themselves or they are dangerous to others. they would be treated under the national health system now in Brazil, which we think it's much better development. So I hope that this makes it better for the people who are in the hospitals because they'll be under the national health system, but also this will make lawyers and defense less reluctant to raise the insanity defense in cases because it'll become better to be treated in those hospitals than to have a criminal sentence. So,
Great. No, and actually, as a connection to that, Dr. Omar, you have a very different situation in Zanzibar, different situation where you don't actually even have the forensic psychiatric hospital. So can you talk about some of the challenges you have there?
Thank you so much first for inviting me from that far.
Thank you for coming.
The journey of one day.
Yes.
Yeah, so I'm really grateful for that, and I'm very happy that I've got a lot of information. I've attended several sessions, which have highlighted a lot of issues, because it's not only that we are dealing with the forensic issues, we're also dealing with issues about gender-based violence, violence against children, and so many issues. But I'm so happy to be here, and as Stephen said, like, in our setting, it's different. It's different in a sense that because we don't have a facility for forensic patients. So what the court do is, after being found like you are not guilty or you are not accountable for the reason of insanity, they usually send them to prison, but the duration of stay is reduced. But because we don't have somewhere to send them, so they are still sent to the prison, and the prison is it's a very cumbersome place. Actually, even to those who are not mentally ill, they might get ill, mentally ill as well, because now we are getting a burden of people who are coming from there with a lot of mental issues, and then we treat them, and then they're going back to prison. So you may find like the patient who has committed crime and has been sent to prison, then get a crisis in the prison, then sent back to the hospital, stays for some time, after stability, goes back to prison, something like that. So for those who have, there are two cases. So there are cases that are sent to prison, but there are cases who are sent home. So for example, like those who have been found unaccountable of the act they've done, so usually they're sent back home to their families, and they're advised to follow what the doctor advised, like they have to continue with the treatment as at the home place.
Are those, is that typically successful?
Yeah. Mm-hmm. But then another problem is when they go back to home, some of them, they don't follow up treatments, and then they go back to us. Yeah, so currently we have a pending case which has done that. Now the second time, now sexual abuse is charged. So it's really a difficult thing. So yeah, unfortunately, we, apart from having no facility resources, we also have a lack of human resources specialized in forensic aspects of psychiatry. So we usually, we as psychiatrists, general psychiatrists, we are the one who are dealing with those individual patients as well. So, but then another issue is sometimes the courts have their own definitions. Usually we don't use a person, insanity. We use a person of unsound mind.
Unsound mind,
unsound mind, and not insanity. So usually they have their own definition in their mind of unsound mind.
The judge does.
Yeah. We also have our own definition, so sometimes it becomes difficult. You may find like you have given the explanations and
exactly your point,
to the individual patient who is the offender, but then at the end of the day you may find like, wow, so the person has been sent to the prison. You don't know why, but at the same time, so when we asked them, they told us what we understand about a person of unsound mind is the one who have long-term mental illness, and not the one who have short-term, like has got crisis and has committed a crime, but those ones are not counted as of unsound mind.
I see. Even if you recommend that they,
they're the one who actually, they're given some verdicts, but the only thing that they consider is reduction in the time staying.
I see.
Yeah.
Can you say a little something more though about your role in the court process? Because we have lawyers here as well, but you're as a psychiatrist, you play a different role. You play a different side of it, and I'm curious, what you, the big takeaways for you.
Yeah, actually, my role is I'm standing as an expert witness.
Yes.
Yeah, to the court. But the thing is, I think there's a what I see is like there's no clear information about how are we linking the judges? How do we? I mean, where are we interlinked? Like we go there giving our witness as expert witness, but then we don't know how did they judge? What's going on? What's going to happen? You don't know anything. Like then at the end of the day, you may hear that person was sent to prison. That person was, So sometimes you don't get a clear picture of what is the link between us.
And do they do a written judgment in the case of these cases? Do the judges write an explanation of why they're doing what they're doing, or do they just make a judgment and send them?
They do them by themselves, actually. They don't even involve us.
I see.
We're not there, actually. We are there giving our witnesses, and then we are leaving.
I see.
Yeah, that's it.
But they do listen to you.
Yeah, they trust us.
Yes.
Okay. I have to have gratitude for that.
But their definition differences sometimes.
Yes.
That's the very problem Linda was talking about.
But then the thing is, for example, like we usually don't get the people who are insane who have done minor crimes. Usually the major crime, murder and sexual crimes. That's it. But the theft, you won't find them there.
Yeah, you won't. Yeah. So part of what we're thinking about in this project is thinking very broadly beyond just legal questions. And the one thing you said connects to some points that we were talking about earlier, and I would like to go to you, Alicia, about this, is that when they send them home for treatment, it often works. And this is unheard of in a lot of mental health systems, and you've studied them in countries around the world, and with a human rights perspective, often on what you're working on. So the bigger picture here, as far as how some of this, how mental health systems, how mental health approaches as a society, might plug into this.
Yeah. So first of all, I'm extraordinarily grateful to having been invited to this panel, and I learned a huge amount just in the lunch conversation, and now listening to Linda and to everybody. I thought before I answer that question, and I was certainly asked because I've done advocacy in mental institutions with what a group that used to be called Mental Disability Rights International is now called Disability Rights International. But before that, I think it might be useful to connect this to the Bergen exchanges and the conversations we've been having all week. I'm a human rights lawyer. I work on health and human rights. And one of the kind of starting points for us is contesting the boundaries of deviance. And that's done. The criminal law is not just a neutral body of law. It's racialized, it's saturated with patriarchy, it's to support a specific property order. And we've had many, many conversations throughout this week about criminalization of abortion, for example, or criminalization of sex work. Similarly, the contestation of the ability of medical professionals to establish deviance, whether it's in physical health, particularly in mental health, say LGBTQIA people, trans people, like that has been a big topic of our conversations throughout the week. And I don't think we should forget it, because much of the struggle for human rights is to see this not as a given, but to see this as a kind of social control that is being imposed on certain populations for the benefit of other populations. So when I started working with MDRI, which is now DRI, I went to various psychiatric institutions from Mexico to the United States, to Argentina, to Uruguay, to Peru, and prisons as well. And my thought at the time was that, you know, the abhorrent conditions in these, what are dungeons, you know, which are often worse than prison conditions, you know, had to be exposed and denounced, and there had to be advocacy. I have shifted somewhat to thinking that that's reasonably peripheral to the main task ahead, which is, you know, the whole construction of these, the more facilities that are built, the more people will occupy them. And in the United States, we have both a carceral system and a therapized society, and that is controlling people increasingly. So the answer in my mind is not just looking at the line of what is criminal insanity, which in the Commonwealth of Massachusetts, we have the model penal code definition, but really looking at the power to determine mental illness and deviance that puts so many people kind of outside of being full subjects and agents and full human members of society. And that is happening increasingly in the United States, where it's now happening to youth in the United States. And we, because we're the United States, we export all our bad ideas, great, bigger. It's happening elsewhere as well. So it doesn't surprise me that people are sent home, and that there are many head of the Department of Global Health and Social Medicine is a psychiatrist, an Indian psychiatrist, Vikram Patel at Harvard, who has talked often about very much better models of treating mental illness in low-income countries than we have of taking the people out of the community, isolating them, treating them as though they are stigmatized and
pharmaceuticalizing them, and
pharmaceuticalizing, which is not evidence-based. There's not evidence. The burden of mental illness in the United States has grown exponentially just as pharmaceuticalization increased.
That's a great point, and we're about out of time because it's gone much quicker than I expected. But I do want to make one quick plug for the Dimensions program, because the Daniil Butenko, one of the postdocs working with me, and another affiliated researcher, Slavka, what's her last name? I forget. Dimitrova from Bulgaria, and Linda have been working on a paper that is actually connected to this very point that you made about misuse of the insanity defense for political purposes, in that case, in former Soviet Republic of Bulgaria. So, and that paper is close to publication.
Of Ukraine.
So, yeah. Oh, and I'm sorry, of Ukraine. The misuse one is in Ukraine.
Yep.
Sorry, forgive me. Yeah. Yeah, Ronnie, and then we'll have to probably, you can have last word.
Okay, I'll just say.
Linda can have a last.
Okay, maybe Linda can.
In the light of everything that's been said, one interesting thing in England and Wales that my empirical research in the insanity defense has shown is that there are now 25 to 30 successful cases a year, but 50% of those are not sent to hospital. So they are, because we introduce community disposal, they can get a supervision order in the community or an absolute discharge. So about 15 a year, if we take the 30, are going to get a community disposal. So no longer the judge then
making
says,
progress.
I think the appropriate disposal is not hospital. It doesn't need hospital treatment. So he or she is going to be sent you get a supervision order, which is a maximum of 2 years. You're supervised in the community, or you get an absolute discharge where you, and there's quite a lot of absolute discharges where you actually walk free and go home because the family say a bit like that they can deal with it. You know, now that's interesting because what's happening is that it's more appropriate now to think about, should we go down the insanity route? Because there's a 50% chance that you won't have to go to hospital at all, right? And you don't get a conviction. You don't get a certificate of conviction. There's no risk of imprisonment at all, right? That's a very important finding, I think, because if we increase the insanity events by introducing moral wrongfulness into it, it would increase the numbers, I think. I don't think it would increase hugely. I think we might get 50 or 60 a year. But it's possible to get 50 or 60 a year, even 100, you get 50% of those people not being sent to hospital. And that is a fantastic achievement, I think, that our law has achieved, unlike most other jurisdictions.
All right, Linda, give you the last
I
one.
just would very quick, just to link also where I started in a way that I think what we have now sure is a little bit like different small glimpse of a very intricate and very challenging issue. Not only in the law, but also more generally in the legal system that law is, so to say, put into operation. And I think how you formulated it, Alicia, now in that you said something that it is about to establish deviance. That is precisely what the law does in this area, and that is why this is also so interesting in a society where we also have movement on a very increased recognition of the right and status of persons living with mental disorders and disabilities. It is in a way intriguing that we at the same time have a criminal justice system where we still, so to say, allow for and actually put into operation very specific and unclear, so to say, definitions of deviance that then steer all these systems. And also, of course, we have tradition, we have a prison system different to abolish, etc., etc. And also, lastly, I always remind people when we talk about this issue, nevertheless, which track you're ending up in, access to mental health treatment is actually a human right that should be accessible to anyone, also those ending up in prison. But that is a truth on paper, not often so realized in practice, at least not globally. And I think, as we have heard, we have so much to learn from each other, and we have just started to scratch on the surface for a very interesting and very inspiring discussion that I truly hope that we could continue. So thanks everyone for listening.